Welcome back to Sovereign Citizen Accountants, the channel where courtroom confidence usually lasts about 30 seconds before reality shows up. Today we've got a sovereign citizen who storms into court with enough energy to power a small city. He's clearly convinced that today's the day he's finally going to outsmart the legal system, educate the judge, and expose the truth. Unfortunately for him, the judge seems completely uninterested in joining his fantasy. Let's watch.
All right. Is that Mr. Crispy who just entered the room?
I object. I object to your assumption and presumption that I'm a Mr. Crispy, a Timmy Leo Crispy, a Timmy L Crispy. That is a trust.
Okay. Thank you, sir. We're going to mute you now, sir. I'm going to explain to you. We're going to mute you now, sir. Very good. I am Judge Lopez. I'm going to be presiding over this proceeding today. This is the state and the individual who I'm referring to as Timothy Crispy appears on both the Cumberland and Gloucester calendars. I'm going to call both cases now. From the Cumberland calendar, the state of New Jersey versus Timothy Crispy. This is under warrant 2026-995-0601. Under the Gloucester calendar, it appears as state of New Jersey versus Timothy Crispy under warrant 2026-264-0814. Counselors, their appearances for the record. I'll start with the Cumberland State.
Good afternoon, Your Honor. Chris Kelleher on behalf of the state.
Christopher Connor, Office of the Public Defender on behalf of the defendant.
And from the Gloucester calendar.
Good afternoon, Your Honor. Assistant Prosecutor Christopher Ammon on behalf of the state as well.
Christopher Connor, also at the Public Defender's Office still, on behalf of the defendant for the Gloucester matter also.
All right. And so I know you do. It's been placed on the record. The purpose of this hearing is to advise you of the charges that were filed against the individual known as Timothy Crispy, to advise you of the maximum penalty should you be convicted of those charges, to ensure that you have been advised of certain rights that you have, and to advise you of your next court date. As it relates to warrant 2026-995-0601, you were charged with 3 fourth-degree offenses: cyber harassment, a retaliation for past official action, and harassment while imprisoned. For each one of these 4 fourth-degree offenses carries a maximum of 18 months in jail and a $10,000 fine. Under the Gloucester warrant, which is, I will reference, it is warrant 2026-264-0814. You were charged with a third-degree cyber harassment. Third-degree offenses carry a maximum of 5 years imprisonment, a maximum fine of $15,000. It is my understanding that you did not have an opportunity or to watch an informational video, but you're entitled to know certain rights that you have. And at this time, I'm going to advise you of those. You are presumed innocent unless the state can prove the case against you beyond a reasonable doubt. You have the right to remain silent. Any statements that you make may be used against you. You're being represented by an attorney from the Public Defender's Office for this proceeding only, though you may qualify for continued representation. I know you object, and I know that you did not submit to a 5A application, but this attorney has been assigned to represent you for this proceeding only. You cannot afford a private attorney. Continued representation would require you to submit to that application for the. I know you do. I know you do, sir. Thank you. Please be aware that the public defender representing you today may not be your attorney after your case proceeds to the court that will ultimately hear your matter. If you are not a United States citizen and if you plead guilty to or convicted of certain offenses, it may result in you being deported from the United States and may prevent you from being readmitted to the United States if you leave voluntarily, or may prevent you from ever becoming a naturalized American citizen. You have the right to seek the advice from an attorney about the effect a guilty plea would have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless a prosecutor has filed a pretrial detention motion or you have outstanding detainers that cannot be resolved today. If the state has filed such a motion, your case will be heard at a later date to determine whether you can be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offenses. You will have the right to an attorney. If you cannot afford an attorney, one may be appointed to you. You will have the right to testify, to present witnesses, to cross-examine witnesses who appear at the hearing, and to present information by proffer or otherwise. Should you choose to testify at the detention hearing, Your testimony would not be admissible against you on the issue of whether you were guilty or not guilty, but your testimony may be admissible related
I
to
object.
pretrial release.
Violation
I know
of
you
due
do.
process.
Violations of conditions of release or perjury or for the purposes of impeachment. Under the court rules, the state can request a 3-day postponement of that detention hearing. You can request a 5-day postponement of that hearing. While awaiting the hearing, your commitment to the county jail would continue. If the state withdraws this motion before the hearing, you would be brought back to court and released on your own recognizance or with conditions of release. You have been charged with indictable offenses, which means you have the right to a hearing as to probable cause. You have the right to an indictment by grand jury and the right to have a trial by jury. You may also choose to waive an indictment or a trial by jury. If you choose to waive a trial by jury, you would be tried by the court. In that instance, a judge rather than a jury would determine whether you were guilty or not guilty. You may be eligible for certain diversionary programs. The pretrial intervention program may be available to you. There's a $75 application fee for that program, which can be waived if you're found to be indigent. You may be eligible for the recovery court program. In order to be considered for that program, you must submit a separate application. Some counties have the mental health diversion program for which you may be eligible.
mentally
If you are eligible, a treatment provider will contact you while you are in jail or upon your release. Your court staff or your attorney can direct you to the relevant information about these programs. A special note for military veterans, veterans of the United States military, a program called the Veterans Assistance Project exists to provide veterans with referrals to community-based resources for services related to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible mentoring by another veteran. In addition, you may qualify for the Veterans Diversion Program. Our court staff can provide you with a brochure describing the program and an application for both programs. Court staff can also help you in completing the application. As I just advised you, sir, you cannot be detained today unless the state has filed a motion seeking that you be detained pending the resolution of these charges. Upon my review of both the Cumberland and Gloucester calendars, the state has filed these detention motions on both those warrants, which means, sir, you cannot and will not be released today. There's nothing you can say or that your attorney can argue on your behalf that's going to change that fact for today. Sir, there are detention motion hearings that have been scheduled. As it relates to the Cumberland matter, a detention motion hearing is scheduled before Judge Arbitier on July 21st. As it relates to the Gloucester matter, a detention motion hearing has been scheduled before Judge Smith on the same date. The courts will be able to coordinate which hearing will come first so that you are able to appear for both. Anything from the state in Cumberland as it relates to this matter that you'd like to place on the record, sir?
Nothing further, Your Honor. Thank you.
Anything from the state as it relates to the Gloucester County matter?
No, Your Honor.
All right, Mr. Kona, anything you'd like to tell Mr. Crispy?
Judge, since he didn't fill out a 5A, the court can't appoint us to represent him. So it doesn't look like we're going to be representing him because I doubt he'll start getting cooperative on the 5A. So there's really nothing for me to say to him.
All right, very good. All right, that concludes this proceeding, sir. We're going to disconnect now. Good luck to you on your detention hearing.
Well, that went about as expected. You have to appreciate the confidence. This guy walked in acting like he was about to deliver the courtroom speech of the century. Meanwhile, the judge treated his entire performance like background noise at a grocery store. What I liked most was how she didn't take the bait. No arguing, no debating, no getting dragged into the sovereign citizen rabbit hole. She simply kept reading what she needed to read and moved the hearing along. That's professional level patience right there. Honestly, that's why I didn't interrupt much. The judge was already handling it perfectly. Why ruin a masterpiece? But don't go anywhere, because we've got another hearing coming up. This time, it's a pro se defendant. Now, not every pro se defendant is a sovereign citizen, but sometimes they come with the exact same energy. They skipped reading the script, but somehow kept the attitude. Let's check it out.
All right, the court calls 25M 1656, 25 CR 1110, 25 CR 1002, 25M 1537, and 25M 1600. Mr. Keller, I'm sorry, Mr. Beller appears by WebEx today instead of in person. And from the jail, why is he appearing from WebEx?
Because of
Custody.
Custody restrictions.
Yeah, it's a
Okay.
Housing restriction.
All right, thank you. All right, then what the case comes on for today is motions hearing. The motions were filed timely in 25 CR 1002. However, there has been a motion in one of the cases to a motion with regard to having a competency evaluation. Ms. Malcolm, I noticed that this is not filed in all of his cases.
Your Honor,
Hold on, Mr. Beller, you need to wait, okay?
I'm actually pro se. I'm representing myself.
No, you're
Madeline
not.
Malcolm, yes, I
No.
filed pro se on myself, so I'm representing myself. Madeline Malcolm, I've informed her that she is no longer representing me. I am a
Okay.
pro se litigator and representing myself. Madeline Malcolm has no business being in the courtroom representing me today.
I have not approved, nor have I considered any motion to have
Commander
counsel
Vaughn,
dismissed.
I've already put in
Mr.
pro
Beller?
se.
Mr.
Okay.
Beller, you
You're
need to
not
stop.
understanding what I'm saying.
Mr. Beller,
Commander Vaughn is.
all right. The court notes that there has been a motion filed, as I said, raising competency in one of the cases. It has not been filed in all of the cases.
I apologize for that, Judge. I can file it in the rest of the cases.
Okay, so that it's your intent to file it in all the cases?
It is. I was just filing all the motions in that case. And I
Okay.
should have done the others.
All right, for the record, the court muted Mr. Beller as he was not abiding by the court's order to stop talking over me. Mr. Beller, I have to advise you of your competency and the motion that's been raised by counsel with regard to your competency. I'm going to read the advisement to you, and you need to listen to it. And then I will unmute you, and you can ask questions at that time. Do you understand? You can nod your head yes if you understand me. All right. Well, the court notes that there was evaluated by one or more physicians or psychologists. Because your attorney has raised the issue of competency, this constitutes a waiver of privilege to reports of this or subsequent competency evaluations, as well as information relied upon by the evaluators. You have the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine your competency. Any statements you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify at any subsequent criminal trial and at any sentencing hearing held in the case if you are found guilty. You have the right to request an evidentiary hearing to contest any determination of competency. You have the right to be re-examined by an expert of your choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At a hearing to determine your competency, you have the right to be present in person to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make an opening statement and closing argument. If you're found incompetent to proceed, then the criminal proceedings will be suspended and you may be committed to the Department of Human Services for a portion of the maximum term of confinement that could be imposed for the highest level of offense with which you are charged. Restoration services may begin immediately unless either party objects, in which case the court will hold a hearing on the objection. If committed, you have the right to request a hearing as to whether your competency has been restored. If you are found to be restored to competency, then the criminal proceedings will resume. Let me ask you, Ms. Malcolm, I also note Ms. Bovee is on the case. Ms. Malcolm, did you have an opportunity to speak with your client with regard to the issue?
I did not. I was trying to. He did not want to talk about it.
Okay, that's fine. All right, then.
The so-called public defender.
Mr. Beller, the court is now going to ask you if you understand the rights that the court just read to you.
I've already gone to the Colorado Institute for Mental Health in Pueblo and been found competent. I've already had 3 competency evaluations. The fact that you're trying to raise competency again, okay, it's a gross violation of my right to speedy trial.
I only
And
asked
my
you, Mr.
rights.
Beller, if you
Okay.
understand the rights that the court just read
I
you. It's a
am
yes or no question.
pro se. What does pro se mean to you?
And there it is. Notice how the court asks a simple question, and somehow we end up taking a scenic tour through a completely unrelated topic. It's honestly impressive. Some people could turn "What's your name?" into a 20-minute constitutional lecture. The judge is trying to get information. The defendant is trying to win an argument that nobody else is having. Classic mismatch.
All right. The court finds that Mr. Beller is not answering the question with regard to understanding his rights, and
No,
that's
I
okay.
understand my rights, my Miranda rights. What
It's
are
not
the rights?
Miranda rights. Do not unmute him again from the sheriff's office. All right. So the court is going to order the Department of Human Services to conduct a competency evaluation of Mr. Beller. The evaluation will occur at the jail, and the court will review this in 28 days to determine whether or not the evaluation has taken place. The court notes that the last competency evaluation was conducted in January, and Mr. Beller was found competent at that time. However, his attorney has raised the issue again, and the court finds it appropriate to conduct a new evaluation. And that'll be the order of the court. The court will stay the motions hearing and the jury trial that's set for August 17th until such time as the court hears back from the evaluator from DHS. I'm sorry, Ms. Jones, I failed to mention that you're here. On behalf of the district attorney's office, that's my fault. Ms. Jones.
Your Honor, I just want to make sure that the record is clear since we, with setting a new review date in 28 days, that's going to be within the time that the current jury trial is set. And I know the court just made the record that the proceedings are stayed. So I just want to make a record on speedy trial.
Certainly.
So that when we come back, if it's, depending on what the evaluation is, that we know what that amount of time is. So from my perspective, under the speedy trial statute, that the defense filed their motion to raise competency on June 24th, and then the court, I think on June 26th, filed the motion to convert this for the advisement. I think that's when the issue was raised. And so my perspective is that there should be a tolling from that date to, when the next hearing is. But calculating from June 24th to speedy trial currently is October 15th. So I'm calculating 113 days is remaining on speedy. And I just wanted to put that on the record so that we have that, because I have a concern speedy might be an issue when proceedings restart.
Okay, I don't share the concern. I understand the people's issue.
Mhm.
Speedy's told from, and the court typically tolls it from the time that I do the order, which would be today.
Okay.
I'm not going to toll it because I didn't make the determination until today that there would be an evaluation, so I've got to toll it from today's date. That said, Speedy's told, that's statutory, and the court, if that happens, if it happens that we get the evaluation back before the trial date, then we'll deal with that tolling and add the number to that date, but I don't foresee that occurring. That said, we'll take it up as soon as I have the status of the evaluation back. Let's set it for a review. Well, when did I said 28 days, right? So what date do we have for review? All right, that is the trial.
Yes.
Let's set it for the trial date, so the Monday at 8:15. So August 17th at 8:15.
Is the court going to maintain the trial date, I guess, is my question, because motions have been filed by defense. And so
Well, let me ask what the defense would like to do. Right now, motions have been filed. Any hearing, as I said on the record, will be told until this evaluation is done, which means they're going to be reset.
Right.
I'm not taking them off in the very unlikely event. I'm not going to take the trial date off just yet. In the unlikely event that we get an evaluation back, that evaluation says he's competent to proceed, and then we can discuss how the trial should come off if it's before August 17th, which I don't believe that will happen.
Correct. So that's why, from my perspective, I don't think it makes sense to maintain the current set trial date. And it's just going to be, we're going to have to reset within the remaining days that we have at that point in time.
I like to get to that point and then we'll have the calculation at least.
Okay.
It, I honestly don't care either way. It's just, I'm thinking, I think into the future about the calculation, and it's easier to this court to have the date set for trial that's set, because I don't really have, although that said, I don't have a position from the defense. We can vacate the trial, we can vacate the motions hearing and reset at a later time. That's fine with the court.
At this point, if the trial date was set and he was found competent before the trial date, I would have to ask Mr. Beller to choose between some constitutional rights.
That's right.
And I'd have to consult with him. So I don't have the answer right now because I can't consult with my client.
All right, then let's keep the trial date set. Let's report on August 17th at 8:15, and then we can deal with whatever the situation is at that time.
Okay.
All right, anything further?
So Judge, before we go, I know Mr. Beller is talking. I really want you to listen to me. I know you don't want me to represent you. Your mother is here. She wants me to talk to me about the case. If you're okay with that, nod yes. Okay, no. Okay, thank you. That's just the answer I've been looking for from you,
All right, we'll be in recess.
Judge.
Thank you.
And that's a wrap on that hearing. You can definitely tell this defendant came in with a bit of an attitude. The interesting part is that he had already passed a competency evaluation previously. So it seems like the court just wanted to make absolutely sure before letting him represent himself. Probably a wise decision. Because if this is how things are going before trial, I can only imagine what happens when witnesses, evidence, and actual legal arguments enter the picture. Still, credit where it's due. Representing yourself is difficult. Representing yourself while arguing with everyone in the room is apparently even more difficult. As always, let me know what you think down in the comments. Which hearing was more chaotic? The sovereign citizen trying to educate the judge, or the pro se defendant determined to answer every question except the one that was asked? If you enjoyed the video, hit that thumbs up button, subscribe if you're new, and I'll catch you in the next courtroom adventure.